You may be seated. Mr. Brignac?
Thank you, Your Honor. May it please the Court, Eric Brignac for Appellant Byron Antone. It is uncontested that for the past 14 years of his life, Byron Antone has said and done everything possible to demonstrate that here today in 2013, he is not the angry, violent substance abuser who entered tribal jail in 1999. It's hard to think of what else he could have done to demonstrate volitional control over the mental illnesses that plagued him as a young man and which he still has a diagnosis of today, but which manifest fundamentally differently than they did in 1999. And in the light of that record, the district court had an obligation to address Mr. Antone's evidence instead of effectively summarily dismissing that evidence. That error, along with the district court's committing of Mr. Antone based on the two most common mental health diagnoses in the Bureau of Prisons, constitutes reversible error, and the commitment order in this case should be vacated. It is first probably worth noting that Mr. Antone suffers, according to the district court, from antisocial personality disorder and from substance abuse. But those diseases exist certainly on a spectrum. And if we look at Joint Appendix 1132, that's Dr. Gutierrez, that's the government's doctor, he talks about how good Mr. Antone's coping mechanisms have been.
Let me make sure I understand the posture in which you are presenting this. You've got the three different prongs here we're looking at, and it appears to me you're conceding at least two of them.
Yes, Your Honor, exactly. He certainly has committed acts of sexual violence in the past, and he certainly suffers from substance dependence. We disagree that he suffers from antisocial personality disorder, but we're not saying the district court was clearly erroneous. The question and what this hinges on is the third and most significant prong, which is Mr. Antone's volitional control. And
so in doing that, my question goes to, it looks like you're making an interplay between the second prong and the third prong, insofar as the significance of the type of mental illness.
yes, and the statute itself does sort of merge those, Your Honor. I think it is, this court has talked about it, and I agree, as sort of a three-prong test. The statute sort of merges the second and third prong and talks about a mental disorder as a result of which you would have a serious difficulty in refraining from sexually violent conduct.
And it's your contention that mental illness must relate to some type of sexual conduct or characteristic?
Your Honor, our maximal position, which I don't think this court needs to reach, is that under the language of the statute and under the due process clause as interpreted by Crane, there needs to be some sort of paraphilia. However, in this case, that is certainly that is a constitutional ruling. I do not think this court needs to go that far, because in Mr. Antone's case, the government has not presented evidence that his antisocial personality disorder and his substance dependence rises to the level of causing him that level of volitional control. It's worth noting, again, antisocial personality disorder exists on a spectrum. In our office, we have a lot of these 4248 cases, and we see antisocial personality disorder. We have clients who've kicked open locked chain link fence exercise cages so they can get to a guard. We have clients, when I go visit them, I know I have to budget an extra hour or so because they're in the SHU segregated housing unit because they're always picking fights. Mr. Antone, while possibly having, this mental illness of antisocial personality disorder, has demonstrated exceptional volitional control. Mr. Antone voluntarily goes to talk to a counselor. Mr. Antone meditates. Mr. Antone beads. Mr. Antone, again, over the past decade and a half of his life, has demonstrated that, this label of antisocial personality disorder and this label of substance dependence, again, these are mental diseases on a spectrum. He's on the far left side of the spectrum, and he's demonstrated volitional control. Now, your point, Judge Wynn, about the actual paraphilic diagnosis, there may be, as we say in our brief, a hypothetical case where someone has a non-paraphilic diagnosis that ultimately could cause them to meet criteria under the statute. I think Justice Scalia points out in his dissent in Crane, someone with a delusional disorder, where he believes that every woman he meets wants to have sex with him. So there you have a delusional disorder, a non-paraphilic disorder, as a direct result of which you may have serious difficulty in refraining. That's not before the court today. What is before the court today is a case where the government doctors all talked about, all believed he had this paraphilic disorder. So right there, the three-legged stool, if the government is basing its commitment order on the expert opinions, the primary core of the expert opinions has been kicked out from under the stool. I mean, look at Dr. Phoenix herself. The district court's entire analysis of Dr. Phoenix's position is the court agrees with the latter conclusion. That's it. I just quoted the entire thing. But look at what Dr. Phoenix says. In Joint Appendix 417, when the magistrate judge is asking her, saying, okay, what is this distinction between someone with a paraphilic disorder and someone who just is a bad man, who may just be a rapist? Her answer isn't the government would have it that, it doesn't matter. Her answer for 2 pages is she goes on to explain it is a paraphilia. She believes, and her answer is contingent on, it is a paraphilia. You look at, again, the government brief at 22 summarizes it. She actually says herself that the theory on which the government relies and the district court relied, that, he has a drink, and if he has a drink, he loses control. She says that theory, that's too simplistic. That's not what this is about. She believed, and she was wrong, according to every judge to have looked at this case, he suffered from a paraphilia. Even Joint Appendix 420, where she says, the question is put straight to her. Do you believe that he could be committed without a paraphilia? She says, yes, but look at her reasoning. Her reasoning is that, because I think even without a paraphilia, he's likely to do something again. That's not the statutory standard. That's not the constitutional standard. She's not a lawyer. She's not a judge. We don't hold her to that. But she was basically saying preventative detention. I think Mr. Antone may commit a crime if he gets back out. So yeah, he probably does still meet criteria. That's what she says at 420. The district court says, I agree with that conclusion, but that conclusion's wrong. That conclusion necessarily, as a matter of law, leads to the position that somebody who's in the Bureau of Prisons with a substance abuse problem, with an anger problem, is, civilly committable. Well, we've just said at that point that, 70% of the people in the Bureau of Prisons are civilly committable? If we draw that Venn diagram with antisocial, substance dependence, and people in BOP, there's more overlap than separation in that Venn diagram.
So you're not saying that the illness itself has to be linked to sexual type conduct or sexual illness, but that if it is an antisocial type disease, it still must show the level of severity that would indicate the lack of volitional control.
I believe that that case is possible, Your Honor, that there could be someone with an extreme antisocial personality disorder, much more extreme than Mr. Antone's, such that we can save that case for another day, that person could be committable. In this case, where we have someone who voluntarily sees a counselor, who has entered all of these programs to improve himself, who meditates, who beads, who works as an orderly, who is trusted by the Bureau of Prisons.
Well, that's evidence in his favor, but you have 2 government experts, as you pointed out. Some of it is the interpretation of the evidence as the experts see it, but they do have their opinions, and the trial judge is put in a position. What's the standard? Is it clear and convincing evidence?
She must find that the government has met its burden by clear and convincing evidence. Yes.
And so given that standard, on review, if there is evidence that goes in the opposite direction, even though it could go in your favor too, aren't we bound to follow in that direction?
No, not in this case, Your Honor, because this is not a case where, the government experts presented a case, our experts presented a case, and the district court said effectively, I believe the government experts. The district court removed, again, if it's a 3-legged stool, she took out 2 legs. The district court said, no, he doesn't suffer from a paraphilia. that eviscerated the government's evidence.
Let me make sure I understand.
Yeah.
I thought the magistrate judge found that, but did the district court specifically say he didn't find it? I thought
The district court, the magistrate judge found substance dependence. The district court found substance dependence and antisocial personality disorder. No judge found a paraphilia, found in Mr. Antone's case an attraction to teenagers or prepubescent children or an attraction to non-consenting sex.
It's been a while since I looked at the record, but I thought the district court judge disagreed in terms of the paraphilia, but found there was a basis otherwise.
Yeah, the district judge found no paraphilia, but found commitment anyway. Why did she do that? How could she do that? Well, I'll give you her analysis in toto. She says, Dr. Phoenix said he could be committed without a paraphilia. The court agrees with that conclusion. And as I hope to have demonstrated, if you look at the record, Dr. Phoenix's position doesn't say that. Dr. Phoenix insists he has a paraphilia and based her conclusion on that. And on Joint Appendix 420, where she does say, this is what the district court says, she agrees with that conclusion, Dr. Phoenix at that point is talking about preventative detention. And again, Dr. Phoenix isn't a lawyer, Dr. Phoenix isn't a judge. I don't think it's, to her detriment she holds that and believes that, but, that's preventative detention. That is the core of the Crane opinion in some ways, and even the Hendricks opinion. That's something we know that the courts do not do. If I may turn briefly to the question of the supervised release. Again, that's part of, we think that to the extent the district court erred there, that is reversible error because the district court relied on the absence of his supervised release. It was not up to the district court in the Eastern District of North Carolina to collaterally tell Mr. Antone's sentencing court, you do not have supervised release. Right now, as we speak today, there's a judgment, a criminal judgment from the District Court of Arizona. And if you read that judgment, it says Mr. Antone has a term of supervised release. Unless and until his sentencing court says that is not the case, it's not up to the district court in North Carolina or any other court to say that that judgment is invalid. I certainly understand what the district court was trying to do. I think she was trying to be somewhat proactive and read the Turner case. But the Turner case, as we point out in our brief, there's a lot of judicial tolling doctrines and a lot of other ways his supervised release may survive. And it bears noting Mr. Antone wants this supervised release. Mr. Antone, and again, tell me if this is someone who has real antisocial personality disorder and is, going to have serious difficulty refraining. Mr. Antone went to his sentencing court and said, please order me into a halfway house. Please give me this opportunity for a year. I want to spend a year at home in Arizona in a halfway house transitioning back into the community. They say Mr. Antone's still a substance dependent. Yeah, he is. This is a disease that's going to be with him for the rest of his life. But what more could he do? He goes to Alcoholics Anonymous. He takes the classes. He wants to transition. He sees these resources offered. I mean, this court sees it all the time. Goodness knows in our office we see it all the time. Criminal defendants who don't take advantage of these programs. They're young. They're angry. They just want to get out. They're on the back of their head. They're thinking they're going to offend again. But then sometimes you have someone who doesn't do that.
Mr. Brignac,
Yes.
Can I ask you a slightly different question?
Please.
Really of a housekeeping nature. I am aware, as I think all of us are aware, of the challenges facing the judges in North Carolina, really all three districts, because of vacancies and so forth. But I was a little curious, and I remain a little curious, maybe you can clarify for me, in these civil commitment cases, is it the routine practice for district judges to refer to magistrate judges to conduct the evidentiary hearings? I would have thought that it's not, and that these are the kinds of cases, understanding that all of the judges in the district are really overwhelmed by work, that a district judge, more likely than not, ought to be hearing herself or himself.
Your Honor, it is not routine. and the vast majority are heard by the district court, and Judge Flanagan herself hears most of her cases. This is the only case from our office, and Your Honor, I believe, and maybe Mr. Breedenberg would know better, I think there's one case in front of a CJA panel attorney that may also be heard. I certainly agree with you as a matter of practice, and we actually pushed that issue. You know, it's worth noting, you know, we had this case. We have, you know, at our max, we had over 100 of these cases. And you can't help, you know, you're zealously advocating for every client, but you cannot help but sort of put them on a spectrum. And Mr. Antone was on the far right side of that spectrum. In all candor, we were somewhat surprised the government didn't consider dismissing his case. And so we wanted this heard in front of a district judge. In fact, when you have a case this strong, it was sort of really disappointing to sort of add that middleman. And I would say possibly if Judge Flanagan herself had heard this evidence directly and seen Mr. Antone and seen his reaction and watched him sitting there, we may be in a very different appellate posture. I may be sitting at that table otherwise. So I agree with you. That said, having done the research, I do think the Federal Magistrate Act is extraordinarily broad, and I do think it probably, we've concluded that it was within the district court's power to allow the magistrate to do that, though certainly prudentially, I don't agree personally with the practice. If there are no further questions?
Well, you didn't mention the word judicial estoppel, and they seem to pop up in your brief a little bit there on that.
Yes, and that, Your Honor, certainly gets to the question. Mr. Antone went into his sentencing court and said, please alter my supervised release. He argued in this case to the federal magistrate. He brought in a special witness, Ann Schrader, to talk about his supervised release. He has argued in front of his sentencing court in the Eastern District and relied on this supervised release, which, by the way, he wants. And the government or the district court's argument that he may be able to go into his sentencing court and say, I don't have supervised release, I think that's the core of judicial estoppel. You know, you've been relying on this supervised release, and now you're coming in and saying you don't have it. I think he would just be estopped. And I think, you know, under the law, and again, under what I think Mr. Antone wants, the day he gets out of Butner, he begins his supervised release term day one, and he'd be estopped from arguing otherwise.
Has there been a case to hold anything close to what you are talking about under these kind of facts? Where someone has been told you're going to get supervised release, and you say their reliance upon it is important in this instance where the court subsequently takes it away?
No, Your Honor. And I think this case...
Sounds rather interesting. I'm not sure I've seen anything like that.
No, I think this fact pattern, certainly I've tried to do the research. I did the research in writing the brief. It looks, if not unique, it's certainly obscure enough that I wasn't able to find another instance. Civil commitment at the federal level...
But good, so you put it forth?
Your Honor, I think that we put forward the doctrine of judicial estoppel, and I think on the merits of that estoppel, and just because something hasn't come up before doesn't mean it can't come up the first time. There has to be a first case to hold something. And if I may just finish, Your Honor, with the red light on, I also think...
responding to...
Responding, yes, of course.
Yeah, you may, yeah.
You know, if we flip that around, the burden should be... The unique thing that hasn't happened before isn't us arguing judicial estoppel. It's a district court in North Carolina telling a district court in Arizona, this supervised release that you ordered on this criminal defendant is null and void. That, to me, is the thing that's unprecedented, and that ultimately was the legal error.
All right.
Thank you, Your Honors.
Mr. Breedenberg?
Thank you, Your Honor. May it please the Court? My name is Mike Breedenberg, and I represent the appellee of the United States of America. If I may, I'd like to start with Judge Davis's question with regard to whether these cases are handled by magistrate judges. And I agree with Mr. Brignac that most, if not the vast majority, are handled by the district judges themselves. In this particular case, it was one of the earlier cases, and the magistrate judge was granted the opportunity to provide the evidentiary hearing and the M&R, the memorandum and recommendation. However, what's important to note here is that when Judge Flanagan got the case from the magistrate judge, she did one of two things. She either adopted the facts and the conclusions of the magistrate judge, or if she didn't, she conducted a de novo review of the record with regard to certain questions. And I think that's the important piece here, is that Judge Flanagan did not just either accept or reject what the magistrate judge did. If she rejected, she actually conducted her whole review. She noted that in her order, that she conducted a clear, complete review of the entire record and made certain determinations. And one of the determinations that she made was the additional diagnosis, the determination of the diagnosis of antisocial personality disorder. As has already been mentioned, prong one, as to whether Mr. Antone has engaged in sexually violent conduct or child molestation, has been conceded. It's not appealed. And also, the diagnosis of polysubstance dependence is also not challenged and not appealed.
The issue that seems to be focused on is on that third prong.
That's right.
And I guess initially in reading it, it seemed to me as though the defendant was saying this had to be some type of sexual illness, connected illness, mental disorder. But his point seems to be more that once you took away that paraphilia, you took away what he characterized as 2 legs and a 3-leg stool. How do you respond to that?
What I heard the argument was that the position is not that a paraphilia is absolutely required. I understood the argument to be that in this particular case, the evidence wasn't strong enough for the antisocial personality and the polysubstance dependence. The government certainly disagrees with that. In this particular case, the district court considered, again, the entire record in determining whether those 2 diagnoses combined together are enough to cause a volitional control problem with Mr. Antone. And specifically, she adopted, it's also important that she adopted 17 pages of the facts of the magistrate court. And none of those facts were challenged. Those facts included the positive things that Mr. Antone has done, and certainly the bad history and the multiple rapes and child molestations that Mr. Antone has done. So the district...
Now, tell me about the expert witnesses. From what I understand, the defendant's attorney just said is that for the most part, the experts relied upon the determination that the illness was paraphilia, and that their opinions were based upon that illness. But the district court specifically said, no, this is an antisocial, this is a different type here.
If you look at the testimony and the reports of the experts, the government experts, Dr. Gutierrez and Dr. Phoenix, did in fact believe that Mr. Antone would be diagnosed with a paraphilia. However, they were both asked as to whether they would determine that he would be sexually dangerous without the paraphilia. Dr. Phoenix specifically said, absolutely, he would be dangerous, he'd be sexually dangerous, he'd have volitional control problems without the paraphilia. So, although the government experts did believe that he had some paraphilic traits, their analysis of the facts concluded that his other 2 diagnoses, the polysubstance disorder and the antisocial personality disorder, together would make him sexually dangerous.
But the question, though, is, it's like asking an expert, do you think a person, if they go out on a drunken binge for the weekend, would they be dangerous? Yes, they would be. Obviously, they would be. But the question is whether or not, in fact, these maladies would render him without volitional control. That's the question. It's not whether or not they would project. As counsel, I think, rightfully said, this is not just projecting. And demographically in prison, as he said, antisocial behavior, that's so general and broad. It is a DSM-3, but it's so broad that you could say, well, I predict that half of you are going to be recidivists. But we'll keep all of them there. It's not that. It's the question is, what is the evidence that's demonstrated, other than his past sexual behaviors, that he can't control himself with respect to sexual assault? Just answer that if you would.
The courts, there's very few courts that have actually addressed the issue of the the level of antisocial personality disorder that's required. However, the Seventh Circuit addressed it in the Brown v. Waters case and mentioned that in a particular case, antisocial personality disorder alone could be enough. Also, this court recognized in the Caporale case that the scope of the federal statute is broad enough to encompass different diagnoses, whether they're in the DSM-4 or 5 or not.
Well, absolutely. That's
So,
absolutely.
The point is that if the individual's diagnoses, whatever they are serious enough, that would be enough for commitment under this statute. Now, to answer your question specifically, Mr. Antone's situation, his polysubstance disorder, his polysubstance dependence diagnosis, and his antisocial personality together, the district court considered that. And she specifically recognized that in his case, in the way that these two things together manifest themselves in him, that she believed, she was clearly convinced that he would go out and continue drinking and drugging, as he puts it, and therefore fall right back into the cycle that he had done years ago. The specific facts that I think the judge placed a lot of weight into is that Mr. Antone admitted that he's always an alcoholic. He admitted on testimony that there's always a chance that he will drink if he's around a place that serves alcohol. He admitted that when he drinks, he loses control. He admitted that the alcohol and drugs led him to sexually offend. He recognized that. And he stated that he would have continued sex offending if he would have continued drinking and drugging. The only reason he didn't continue drinking and drugging is because he ended up in prison for 14
So
years.
he's going to be detained for the rest of his life because he's always going to be an alcoholic.
No, that's not it, Your Honor.
You think that an alcoholic can become a non-alcoholic?
I think the answer to that, I think that's been dealt with in the courts many times. I don't think there's anybody that would say that an alcoholic can become a non-alcoholic.
I don't think so either.
But I think it's the other points that are important here. And the other thing that the district judge recognized is that Mr. Antone is not a treated individual. He remains untreated. In his brief and in argument, they mentioned that Mr. Antone has taken Alcoholics Anonymous and taken some treatment. But what's important to look at in the record is the level of that treatment. He's gone intermittently to Alcoholics Anonymous classes in prison. He's also attended and taken the 40-hour drug program. 40 hours. That's a week. The Bureau of
Did he
Prisons
cut the 40 hours off, or that's what's prescribed that you had for him?
Well, the Bureau of Prisons has another program, a 500-hour program that Mr. Antone has not engaged in. Maybe more.
Did you offer it to him before he was about to be released, or you did it after that you came and said he should be civilly committed?
Mr. Antone has not had that program either way.
Matter of fact, he came forward and asked to be in a program early on, and you said it's too early.
With that, I'm sorry.
I mean, you meaning, obviously, the government. Right. The government, not you, but the
Right.
government.
I'm sorry, are you referring to the sex offender program or the
Yeah.
substance abuse?
But in terms of, they're all together, aren't they? In terms
No,
of,
there's different programs, which I guess is another point, is Mr. Antone has not engaged or had not engaged in the sex offender program either prior to his ultimate commitment. Now, he has since then, but that's not in the record and not before the court. But again, that's the point I think that the district court took into consideration is the fact that he remained untreated both for his substance dependence and for his sexual treatment. And so to your point, Judge Davis, is that, of course, at some point, Mr. Antone will get to the point where he won't be detained for the rest of his life. I can't tell you when that is.
but how does he get to that point?
Well, the Bureau of Prisons has a sex offender treatment program. In this case, it's considered called the Commitment and Treatment Program. And
But
individuals...
That's not his problem now. And the problem now is that he's the substance abuse that you said is going to lead to that. So how does he you conceded he's going to be alcoholic for the rest of his life. How does he ever get out?
When the individuals, the psychologists and the doctors in the Commitment and Treatment Program do an individualized treatment plan for the sex offenders, they include the entire person involved. And so for Mr. Antone's case, certainly his substance abuse, which is one of his major problems here, will be incorporated in his sex offender treatment program. So
Here's my real problem. I happen to be a judge who actually believes in burdens of proof, which all too often, in my opinion, get overlooked in cases and litigation. The burden here on the government is clear and convincing proof focused on a predictive judgment about the future, obviously. And I have to ask you, if this is clear and convincing rather than preponderance, what is clear and convincing? I don't understand how the evidence in this record can rationally be said to carry the government's burden by clear and convincing evidence. You mentioned yourself, quite appropriately, that the district court basically incorporated wholesale all these great facts, all these bad facts, which are historical facts, and as Judge Gregory suggested in his question, what does he have to do? What would a release decision in this case look like? What else could he have done over the last 15 years to demonstrate a likelihood that he has the requisite volitional control over both his substance dependence and the resulting violent activity in which he's engaged in the past?
I think there were several questions there, Your Honor. And to answer the last one first, I'm not sure the question in the case before the district court was, what else could he have done? I think the question for the district court was she clearly convinced that weighing all the good things and all the bad things, was she clearly convinced that he would pose a substantial risk of danger if released, or have serious difficulty refraining, actually, if released? And she concluded, based on her analysis of the entire record, and it wasn't just of the wholesale adoption of the magistrate's M&R. She did a de novo review of the third prong and of considering the expert's testimony. So she was clearly convinced. What the standard of review for this court is, obviously, did she clearly err?
I'm sorry to interrupt, but I think what your argument sounds like is that whatever the burden of proof happens to be before a trial court, if the trial court has reached that decision, then as a matter of law, the trial court applied the clear and convincing burden.
No, that's not.
In other words, right, I didn't think you meant to say that, because then there would be no sufficiency of the evidence review on appeal, right?
No, I guess
if we were going to say, oh, a judge instructed the jury that they had to apply beyond a reasonable doubt, the jury so concluded, therefore the jury applied beyond a reasonable doubt. Obviously, there's a sufficiency question buried in there that is proper for us on appellate review.
That's right. And on appellate review, the question would be, did the district court clearly err? So the district court determined that she was clearly convinced. And for this court,
is clear error the same as evidentiary sufficiency?
No.
I didn't think so.
No.
So we don't have to find that she clearly erred, do we? If I'm satisfied, and I'm not saying that I am, but if I'm satisfied that as a matter of law, the evidence here is not sufficient to establish the third prong of the civil commitment requirements by clear and convincing evidence, I don't have to find that she clearly erred. I find it insufficient evidence.
I would phrase it a different way, Your Honor. I believe that the district court's determination was her analysis of the facts, and that is the clear error. So if this court were to determine that she clearly erred in analyzing the facts, that's where the clear error standard comes into play. There's not a de novo review in her determination as to the evidentiary standard that she met. She believed that she...
Let me come at it this way, and then I'll stop. If this is clear and convincing proof, what could I take away from the record to make it preponderant proof?
I don't know. I guess what I can say, Your Honor, is that there are so many things in Mr. Antone's case that the district court considered. The fact that all of his sexual offenses, he was drunk. the fact that his substance abuse was so bad that he was passing out every other day. And that's, I think, the important part to recognize in this case, is that Mr. Antone is not just an alcoholic, and he's not just a run-of-the-mill antisocial prisoner. When you look at these things together and how they worked with him, it resulted in him getting drunk, having his antisocial personality affecting his decision-making, and having him go and put himself in situations where he ends up raping either women or children.
15 to 20 years ago. And there's now been 15 or so years where he has demonstrated just about the most enviable record by an inmate. I don't want to overstate it, but if he hasn't been the world's greatest inmate, certainly his record behind the wall would be one that we wish most inmates would emulate, I suspect, from what I've seen the record. He wasn't perfect.
I think the government would agree that he had, as I think the district court recognized, relatively good conduct. There's no question about that. However, the district court also recognized that there are strict structures in prison. There's limited access to alcohol or drugs, and there's certainly limited access to his ability to rape women and children.
But most prisons have special housing units because despite the structure, there is a significant percentage of inmates who don't thrive in that structure. And we have an inmate in front of us today who has absolutely thrived in that structure.
The government would disagree with that conclusion about absolutely
I
thriving.
don't want to overstate it.
But I do want to just point out one more time and restate this, the fact that Mr. Antone's combination of his polysubstance dependence and antisocial personality disorder together make him different. And because of the fact that his access to alcohol and his access to his victim pool in the prison is significantly reduced, that mitigates his ability to do that.
Well, the difficulty with this case is when you look at it and you have those three prongs, a lot of what you're actually relying upon is his past behavior to predict this forward-looking type behavior. The judge specifically said this is not paraphilia, so that's out of the picture. You're now looking at the antisocial type disorder, and the one doctor is this Dr. Phoenix, who says, her diagnosis, and the judge says it, is really based on paraphilia, but she said that he would have serious difficulty in reframing. And is that enough? Serious difficulty in reframing without this diagnosis because of this drug dependency. But getting back to Judge Davis characterized it as being absolutely or certainly he's benefited from the prison. The judge in her findings makes a finding to his credit. Respondent has participated in a substance abuse treatment and evidently has refrained from using drugs and alcohol while incarcerated. How long has he been incarcerated?
13 or 14 years.
So you got someone who came in with a major problem, and all those 13 or 14 years he's there, he's participated, according to the findings. I mean, I know there's other facts there, but these are the findings. In substance abuse, he's refrained from using drugs and alcohol, and so when you come down to it, the evidence must stand, at least the position of the court seems like it has to rest upon Dr. Phoenix's opinion. Is that right?
Dr. Phoenix's opinion, again, was broader than just basing it solely on the paraphilia. I mean, she was asked specifically about what...
Just reading the judge's findings, it said she testified that he would have serious difficulty reframing even without this diagnosis.
That's right.
That's it. I mean, there's nothing else in her opinion other than just that. And I don't know, I guess intuitively, isn't that everybody? How would it not be everybody if you go into prison and you've got a substance abuse and an alcohol problem? You spend 13 years there. You totally refrain from alcohol and substance, according to the judge here. You participate in an abuse program. At the end of it, how I mean, I don't know if you need an expert to say that someone who started out with this, if you're going to use alcohol, you would have serious difficulty in refraining from doing it. Why is that not every case?
I think, may I answer?
Yes, go ahead.
I think that the point is that it's not every case. And in this particular case, the way that these diagnoses manifested themselves in Mr. Antone makes the risk so bad. And the fact that he's gone 14 years without the opportunity to do it is an important piece here. That if he's let out and without the supervised release term or anybody to be able to check
Not
on
just
him.
the opportunity to do it, but no indication of any desire. I mean, no characteristics that would come up. Nothing to show he's trying to access things on the internet, or he's trying to reach out to people, or he's talking to other people. There's nothing there
Other
for
than his
13 to 14 years, based upon the judge's finding. And then I'm just trying to, I mean, this act is really kind of an interesting act in and of itself, but when you come down to it, when it ties into just this substance abuse, alcohol, that he had 13, 14 years ago, and Judge Davis posits, and probably correctly, that you don't just become a non-alcoholic. I mean, you're probably going to be like that. So isn't that every case?
Mr. Antone testified at the trial that he would be at risk to drink again if he goes to a place with alcohol. I gotta say that the district judge probably gave that a lot of weight when she made this determination. If she believed, which she did.
Where did she give it some weight? I don't.
It's in the joint appendix.
Order here.
It's in the joint appendix, Your Honor. It was anywhere between 207 and 242. It was testimony by Mr. Antone. The specific thing where he said that there's always a chance he'll drink if he goes to a place that serves alcohol is on joint appendix 242. And then there was some more testimony where he again explained.
I mean, that's probably common sense. An alcoholic, there's always a chance you'll drink if you go to a place of you serve a drink. I mean, I don't know if that adds anything. Is there something else?
When he was trying to extend his supervised release and those kind of things, did you oppose that?
Say that again, I'm sorry.
When he was saying that he still had time and that the court still had the arm of supervision over him, did you oppose that?
Did we?
Yes.
It would have been the District of Arizona. The government, I do not believe in the District of Arizona opposed that.
Oh, and no one opposed it. The court just made that on sua sponte?
It would have been sort of a modification of the supervised release term. So if that would have happened, the U.S. Probation Office in the District of Arizona would have been involved in going to the court to get that term modified.
Okay. So as it stands now, we don't know whether he does or...
Well, as it stands now, I think that the district court was certainly reasonable in determining that there is no supervised release term based on Ninth Circuit precedent.
And you agree with that?
Correct.
So you would say whenever the day comes, if not today, that Mr. Antone gets out, you would be in favor of just no supervision at all? You wouldn't ask the court to put conditions at all?
I don't know under what authority the government would be able to do that with the Ninth Circuit precedent that's out there.
Mm-hmm. Okay. All right.
Thank you.
You have a little time left?
Thank you, Your Honors. I would have been more worried about Mr. Antone if he would have said, I'm never going to have another drink, I have no temptation, etc. That's just him acknowledging his disease. Joint Appendix 668, the government mentioned that he talked about, I'm going to be drinking and drugging. You know, Joint Appendix 668, look at that. Again, that's awareness. Look at the tense. He was talking about the past. He was in 1999, if y'all hadn't caught me, if y'all hadn't stopped me, I would have kept doing this. And he believes that, and I have no doubt. Again, that's just acknowledgement of who he is. The government belittled somewhat the 40-hour substance abuse. Again, I'd point to Joint Appendix 1238. You know, there was Mr. Antone in the interview with Dr. Dom, talking about the substance abuse, talking about the treatment, that was helpful. And again, maybe for someone in our position, you know, a 40-hour introductory substance abuse class may not be much. For someone who comes from the reservation where Mr. Antone came from, who had modeled for him nothing but alcoholism, those 40 hours, that first sense, I mean, you can almost see that begins this process of, wait a minute.
What do we do
There
with
is
the
something. Yes.
opinion of Dr. Phoenix that even though the court acknowledged the primary basis for the diagnosis of serious difficulty reframing was from the paraphilia, which the court then found was not there, but went on to say that even without that, this person would have a serious difficulty from reframing.
Two responses, Your Honor. I think if you look at Dr. Phoenix's answer on Joint Appendix 420, she was not at that point applying the legal standard under the statute. She was effectively saying that, he is someone who may, he is someone in prison who suffers from alcoholism who may recidivate. I think as you pointed out, Judge Wynn, that could almost be everybody. And the article that was in evidence, the government said we never challenged Dr. Phoenix on her article where she talked about, how antisocial personality disorder is not enough. Dr. Phoenix was their witness. They had every opportunity to call her up and rehabilitate her with that. And maybe this gets partly to what you were saying, Judge Davis, about clear and convincing evidence. If the judge was going to rely on Dr. Phoenix, I don't think there was enough evidence in there to rely on Dr. Phoenix. She applied the wrong standard. She believed there was a paraphilia.
So what do you have to do when this thing comes back up? Because Judge Flanagan points out, as the law is, that that doesn't mean he has to stay there forever. You get 180 days, you can come back. And
He doesn't suffer from a paraphilia, and he's in sex offender treatment. What can he do? Can he stay sober to show he has volitional control over his alcoholism? There is alcohol in prison, and there are women in prison.
What happens after 180 days? Can you ask for a rehearing?
Yes, we may.
Has 180 days expired?
I honestly, I'd have to look at the dates, Your Honor. I'm not sure. The burden of proof switches at that hearing. It is on us, and so it is a fundamentally different proceeding. He's not going to be able to demonstrate any more sobriety than he's already demonstrated. He's not going to be able to demonstrate any more control over his anger than he's demonstrated. I don't see how Judge Flanagan would change her mind. And if I may,
Can you
Judge Gregory.
request a drink in prison so you can see what happens when he gets drunk? That's the only thing I could see that he could do from an empirical standpoint. Let me get drunk in prison and in a controlled environment just before the last act. Of course, you would stop it. You wouldn't let anybody be a victim, but you'd say, okay, test case, and you go in and say, oh, well, he managed to have a good conversation, or he lunged and we grabbed him. But it sounds a little funny, but really it's the case because we're talking about science. Suppose that scientists come here and we rely on them. That's what science does. It tests hypotheses. Instead, what we do is we just allow conclusions, and the law just. So we got to be creative here. You think they might do that if you request that?
No, Your Honor. Obviously, we believe that the commitment order was erroneous and should be vacated. And yeah, Mr. Antone can do nothing. If Mr. Antone wanted to drink that badly, he would have had a drink. There's alcohol in prison. There's homemade alcohol. There's alcohol smuggled in. There's marijuana smuggled in. They give the inmates breathalyzers. There's an understanding that people with substance dependence do this. Mr. Antone hasn't. And yeah, short of, the kind of hypothetical you're presenting there, I think he's done enough. And the district court, at a minimum, had to sort of address that, not just look at who he was in 1999. And we would say, actually, on this record, I think, get to say that there really wasn't enough evidence to commit him. And if I may just conclude, we would request that this court vacate the order and with instructions to release Mr. Antone. Because on this record, I don't see how there could be, by clear and convincing evidence, a commitment. Thank you, Your Honors.
Thank you both. We'll come down and greet counsel and then proceed to our next case.